rentals, right?
Yes. Imagine that.
Yep.
Good afternoon, everyone. I'm going to call the Finance Committee meeting of, I forgot the date, February 5th. Thank you, Maria. Okay. First, may I have an approval of the agenda? Peter made the movement, made the blah. Peter, Stephen seconded by roll call. Rob? Aye. Jill?
Aye.
Oh, yes.
Peter?
Aye.
Stephen?
Aye.
Chris?
Aye.
Jill, or Joanna?
Aye.
Joe?
Aye.
Jeremy?
Aye.
Thank you. Okay. All right. I will now open it to public comment. The vast audience, no one's waving their hands. Anybody online, Maria? No? Thank you. Okay, I'll close public comment. Okay, we are now going to have our public hearing on the annual town meeting 2024 warrant articles and potential adoption of motions. Before we get started, let me set a framework for how this discussion will go today. First is some background. There are 112 articles, and within that, there are 29 citizen warrant articles. The breakdown of these articles is as follows. There's 40 articles that are financial in nature, 25 real estate related, 4 sewer related, 23 zoning related, and then there's 9 that are select board articles that are not in any of the categories I've already spoken to. We have made, to date, the Finance Committee has made recommendations on 24 of the 112, just to keep us focused. The guidance for anyone speaking today, if you are a sponsor of one of the citizen warrant articles, you are strongly encouraged to stick to 5 minutes or less explaining your article and explaining why you're looking for a favorable motion from the Finance Committee. The people who respond to that are asked to stick to 2 minutes or less. The logic behind this is that's what happens at town meetings, so this will be very good practice. Secondly, I will then ask the members of the committee if they have any questions of the people who've spoken so far. And then, of course, everybody can keep speaking as they need to. So that's how we're going to run today's meeting. All right, so typically what happens is I read out each article and ask if anyone wants to speak. I'm going to do it a little differently because there is 112 articles. So articles 1 through 35 are appropriation articles, and they are sponsored by the select board acting as the county commissioners, select board for Board of Health, select board for Enterprise Fund department heads, select board for Airport Commission, and the select board for Community Preservation Committee. I will now take a pause and ask if anyone wants to speak to any of the articles 1 through 35. Anyone raising their hands, Maria? Okay, those are behind us. All right, give me 1 second while I get my little piece of paper out. Where did it go? Ay. Too many files. Okay, that I can't read because I'm going blind. Article 36 is appropriation, African Meeting House investigation. This is a citizens warrant article. The sponsor will come back on February 15th to continue discussing this article. However, is there anyone that wants to speak to it today? Okay. Article 37 is the Adopt Massachusetts General Law, Chapter 175M, Family and Medical Leave. The recommendation from the Finance Committee was motion to refer for further study, and it was unanimous on January 16th. However, is there anyone that wants to speak to that today? Okay, moving along. Articles 38 through 59 are zoning-related articles where the planning board makes the primary recommendation, which we will review on February 12th. The sponsors are both the select board and private citizens. Does anyone want to speak to any one of the articles 38 to 59? Okay. Then now we are on Article 60, which is the select board article, select board sponsored article, general bylaw amendment, short-term rentals. And on this, we will have a discussion today.
Amongst whom?
Amongst ourselves. So, okay. So as I hope everyone's had a chance to read. I did send out a document that compares the 3 articles. So I may go right to Mr. Cohen for the next one and then to Mr. Kopko for the one after that. But we did get a document that compares the 3. I also sent you earlier this afternoon, a summary from John Giorgio, who made it way more clear than my little spreadsheet, but nonetheless, my spreadsheet did help me. So, okay, so with that, I think, Stephen, my back is to you.
Yeah, I'm gonna recuse.
You have to recuse,
Yep.
so does Chris.
Same.
So you have to go sit in the audience. Thank you very much. Because more is to come that we'll want you to be part of. Thank you. Maria, is Stephen Cohen here?
Yes, he
Okay.
has his hand raised. I will let him.
All right. Stephen, I'll turn, Mr. Cohen, I'm going to call you Mr. Cohen so I don't confuse you with Stephen Morey. Could you go ahead and talk to us, please?
Sure, absolutely. So I will thank the committee for having this hearing. I think it's a very useful exercise, and I will tell you I've had some conversations with Mr. Kopko about our articles, about the 2 differences between them, and I certainly don't want to put words in his mouth, but I'll give you my impression of just a brief summary to try and save a little time. There's 3 major or 3 substantive differences between our articles. One is that his would limit the number of units that someone could own. A second one is that his would prohibit getting tent permits and some things like that in STRs. And the third one is that his article would not allow for pre-existing non-conforming status for corporate owners that would otherwise be banned. Otherwise, I think that we do the same thing. In contrast to the Towns article, I think the Towns article is the same or similar to my article, except that it also has a prohibition on STRs in interval and timeshare units. So I guess very briefly, I'm not sure I understand the purpose of the interval and timeshare prohibition on Nantucket. I get why in some places it might make sense because you essentially don't want to turn them into hotels. But on Nantucket, my understanding is there's 2 timeshares in town and the rest are all in Tristram's Landing, and that all of those are essentially weekly intervals only. So I'm not sure that there's a real substantive difference between the owners using them on a weekly churn basis compared to someone else using them on a weekly churn basis. But I think that I guess I don't see the purpose of banning an STR in something that's already on a weekly churn. So if you look at the differences between Michael and I, what we had talked about was that we should try to focus on where there's concurrence and potentially having one article move forward as preferably under the town's name, under the select board art name, if they're willing to do it. That would be a concurrence for all of the issues that are agreed upon. I don't know that Michael felt strongly enough about any of the differences, but he can obviously speak to that. But I think that there's nothing among the rest of our articles except the stuff I mentioned that we disagreed on. So in other words, there's a lot of area of concurrence that would be a good basis for having an STR article that both Michael and I and the town all are in concurrence on, that could move forward and potentially set the basis for regulating STRs and then having more refinement to those later. That's not only one bite at the apple here. Other things could come forward later. So I think that's where we are. We're not quite there yet, but that's where we're trying to get to.
Thank you, Stephen. Thank you, Mr. Cohen. Is Michael Costello on? Maria? Yes. Michael, I'm going to turn it over to you now and then we'll go to the committee to ask questions.
Thank you. Yes, like Stephen said, we are having discussions. I think that we agree that the ideal outcome of our discussions would be that there would be one article that we sort of concur about, likely to be the select board article. But I think there are more discussions to come. We've been talking and I think come to agreement on most everything. The main distinction in my article has to do with pre-existing non-conforming use, like Stephen said. And that's an aspect that I need to think a little bit more about and have some discussions, hopefully with Stephen and the select board. But ideally, I think we'd all like to get behind one article. It seems to me that there's an appetite at town meeting to get regulations passed, and the primary aspect of those regulations being the prohibition on corporate ownership of short-term rentals. So I think that we're moving toward a positive result there.
Thank you, Michael. For the benefit of the committee, if you hadn't had a chance to read the email I sent you that we got from John Giorgio. To summarize, so John took the chart and then summarized, all three versions ban corporate ownership of STRs. However, Select Board and Cohen provide for grandfathering protection. COPCO does not. All three versions allow STRs owned by an LLC, trust, or S Corp, but only if all members are natural persons. Select Board prohibits STRs in affordable housing units. Neither Cohen nor COPCO included this prohibition. COPCO limits operators to 2 STRs. Select Board and Cohen do not. Select Board bans interval ownership units from operating an STR. Neither Cohen nor COPCO address this. All three versions have differences in terms of the findings section. And so that's John summarized it quite nicely for us, I thought. So I thought I'd share it with all of you, obviously. So John, John Giorgio, did you want to add anything before I ask the committee for questions?
I did not hear either Mr. Kopko or Mr. Cohen identify the prohibition in affordable housing units, and I don't know if they're prepared today to say whether they would support that prohibition. I will say that in my almost 40 years of practicing municipal law, I've never had to address an issue that is actually a principle of scope of the article issues in a warrant, which is that you can have more than one warrant article as the warning to the voters of what potentially could be enacted. And what that means is that because all three articles are on the warrant, we could craft an article that picks and chooses, adopts and doesn't adopt various aspects of those three articles. And hopefully the moderator would find that whatever comes out of that process would be in the scope, looking to three different articles on the warrant for that authority, if that makes sense.
It doesn't make sense. Try again, John.
So you know that the moderator always has to make a determination whether an article is whether a motion is within the scope of the warrant article.
Right.
But the moderator is not required to look. So, for example, if we come to an agreement and it sounds like we would go forward with the select board's article with some modifications, the moderator wouldn't have to find those modifications entirely within the scope of the select board's article.
Okay.
She could look at both Mr. Kopko and Mr. Cohen's article as being warning to the voters that the combined article would be considered by town meeting.
Okay. Thank you. Questions from the
So Stephen Cohen has his hand raised, and then Penelope Day.
Okay. First, let me ask the committee before we get too much input. Peter Schaefer?
Thank you, Madam Chair.
Closer to the mic, please.
Thank you, Madam Chair.
We're out of practice.
Okay, yeah, we are. First question is for John Giorgio. John, can you tell me what you think the result would be if we said to pre-existing conditions for everybody except for corporate, do you think we'll have, the 104 units that are corporate owned? Would that create a lot of lawsuits?
I'm sorry, Peter. Are you asking me whether a ban on corporate ownership without grandfathering protection would create a lot of lawsuits?
Correct. Allowing that all non-corporate will be grandfathered.
Well, you have to look at, this is a much reduced scope than what was presented in November. There were a lot of other provisions in that article that obviously did not pass. So I think it's important to look at exactly what this combined article would accomplish. It's clear that all three propose a ban on corporate ownership. And so if that is not grandfathered, I think, and because you have 104 corporate owners, I think I don't want to predict that lawsuits are going to be filed.
Excuse me, John, 104 units, not owners.
104 units, excuse me. Sorry about that. I think if you include a grandfather protection in the ban on corporate ownership, that may or may not reduce the potential for litigation. I don't think it eliminates it altogether, but it certainly would reduce the potential. Peter, I don't think I feel like I'm not answering your question, though.
Yeah. What I'm trying to get across is the fact that if we're we're saying to anybody who's not a corporation, it's okay, you're grandfathered. But I don't know how many people, maybe it's 14 people that are corporates on the island. We're saying they can't grandfather, they have to sell their units and get out of town. I mean, to me, that sounds like it's discrimination. And I think that it would end up with a lot of lawsuits. I think when we discussed it on short-term rental, we agreed with that as well. So that's what I'm trying to figure out. Is the town protected, or with these people, we're going to end up with six people suing us?
Well, Peter, to clarify, only Mr. Kopko's article bans corporate ownership without grandfathering.
Right,
The
I
other
understand.
two do.
I understand.
The
Okay.
other two grandfather them.
So what I'm just
Current corporate owners get to continue to be corporate owners.
Okay. Well, so just Mr. Kopko would have to be convinced then.
So,
Okay, that's enough. One other thing is, guys, just remember, when you do whatever you do, the shorter the better. And the less words and the less paragraphs. We got killed because the last documents were so long and so confusing and changed at the last minute. We really have to make up our mind before we go in there what it's going to be and push to get it through. Otherwise, you're going to be where the other 6 times that we voted, get it voted down.
thank you, Peter. Other questions from the committee before I go to Stephen Cohen? Jill?
Yeah, whoever wants to answer, maybe Denise can. How would this affect your zoning article, Stephen? How's this going to tie in with that?
Madam Chair, through
Go ahead,
you.
Stephen. Yep,
Yeah.
please.
Well, I think they do different things. It's kind of difficult to answer that question. I think that this should happen because they're sort of the different sides of the coin. So Jill, I don't know if you have like a more specific question related to that you want.
I just want to make sure is your zoning article in conflict with like the select board version?
Okay, I can answer that question. The answer is no. The select board article is nearly identical to mine, except in 3 ways. One is they have a significant number of findings. I frankly think that some of those are contentious and erroneous and maybe too many, and I would cut them. But they don't really matter that much. They just because they're just the
Yeah,
findings.
they're just statements.
Yeah. The second difference is the timeshare one. I don't necessarily care about protecting STRs in timeshares. I just don't see any point of prohibiting them. I can't figure out what the purpose of taking intervals that are already on a weekly churn and banning them from the rental market would be. Especially since in the off season, a lot of them get used for weddings and hunting parties and things like that. And then the third difference is the affordable housing ban. And actually, I would agree with that. I think that one is a good policy one. I wouldn't have any objection to that being an added term to what is proposed under my name. I hesitated to call it mine. It's not really mine, but it's got my name on it. So in terms of sort of maybe Denise's question about whether there's consensus on one, I think the select board's article is probably a good vehicle because I don't strongly object to anything in it. Although, again, I'd probably do it with less findings, and I'd probably cut the ban on timeshares.
Okay, thank you.
I mean, from my perspective, I do actually have a problem with the timeshare section of the select board's article. There's 39 of them on the island. And all of them are, so this is from the tax from Rob Rainey. All of them are in Brant Point Courtyard on Swain Street or in Tristram's Landing and have been in place for decades. So in Tristram's Landing, the number of timeshares have gradually decreased over time as various enterprising individuals have sporadically purchased all 15 intervals for specific property. So then they accumulate and come out of the timeshare situation. So I just don't think it's necessary. I think this was a unnecessary addition, and I believe that, or if for some reason the select board is vehemently in love with this particular part of their article, then I think it also has to be grandfathered for the people who currently bought them with the idea that if I'm not staying there, maybe I want to rent it for my week this year. So that would be the change I would want to see on that.
Madam Chair?
If I may, Madam Chair?
Yeah, go ahead,
So-
Jeremy.
No, that's
Oh, sorry.
John.
So go ahead, John, and then Jerry, I'll come to you next.
So I just wanted to point out that the grandfathering protection in the select board's bylaw says that any person or other legal entity, including a corporation, an S corp, trust, etc., that hold a certificate of registration on the effective date of the bylaw can continue to engage in short-term rentals in accordance with their existing certificate. So the grandfathering in the select board's version is not limited to corporations.
Thank you, John. Jeremy?
Yes, Denise, I just had maybe for John a process question. We've got, as I understand it, we have the 3 proposed warrants that we're supposed to review, and then it's possible that we can amalgamate them and create a 4th one, and then put that before the voters. And I'm wondering, what is the process so that we don't create confusion, so that we as a group possibly pull together all 3 to only have one before the voters?
So Jeremy, John, let me have this just to see if I'm paying attention. Jeremy, what we would actually do is we would say, for example, motion to adopt on one of the articles, motion not to adopt on the 2 others, and then the one that we say motion to adopt in our recommendation, we would then make any changes we'd want to see to the main body of the article, like we did last year.
I got it. Okay.
We wouldn't be creating a 4th article. We'd be modifying one, or we say motion to adopt on all 3, and then in our motion, we make changes to all 3. But I think the more elegant and easier for the voter to understand would be my first scenario.
Yes.
Go ahead.
If I may, Denise, so I believe the select board article is the first of the 3 as they appear on the warrant.
It is.
And so the finance committee motion could be it wouldn't even be a move to adopt. You would make a motion to adopt amendments to chapter 123. And in bold, in the warrant booklet. But that the motion would be the substance of what is agreed to among the three parties here. And if town meeting votes a positive, by a majority vote adopts that, then that's going to be your bylaw, assuming it's approved by the Attorney General. So if that's approved, then for Mr. Kopko and Mr. Cohen's article, it would just be a motion to, I guess not to adopt, or you could do a motion to pass over, whatever you want to do, but that would not be they would not be substantively discussed.
Correct. But John, what I really am trying to avoid, noting what it was like at the special town meeting last year, is there was a lot of confusion from the voters.
Yeah.
They were voting on the FinCom's motion on short-term rentals and not voting on the article. There was a lot of confusion. So
Yeah.
I think it would be simpler to say motion to adopt select board article with the following exclusion for the voters. I understand the process and I understand what you're saying. And I also remember sitting through special town meeting last year thinking there's maybe 3 people in here who understand what's happening, one of which was you.
It was? Are you sure?
Please, John, don't, it's
Yeah.
the one thing I'm holding on to here.
I think the difference here, and we can talk about the best way to present this, but the difference here is that if the 2 petitioners and the select board are all in agreement on the version to be presented, you're not going to have the kind of confusion you had last October. Because the vote is going to be presented right in front of them with the wording of the bylaw, and everyone, presumably, I'm guessing, the finance committee would have a positive recommendation as well. And so that you wouldn't have the problem we had last year of the competing versions of the bylaw between the select board, sort of the work group, the finance committee. That created a lot of confusion, which hopefully this would avoid.
So John, sounds like we, as a finance committee, and Denise ought to just get to what we agree on. And then that is what we try and get everybody else to merge into.
Yes, that would be one way of proceeding, sure.
Peter Schaefer?
Just one thing for us to think about, and we had this discussion on the working group, is by not allowing affordable housing to rent, the people that need it most are being neglected. So one of the things that we thought about is putting a limit on it. They could rent it for a month a year, and that would be it. But they could make so much money in that month that it would really make a difference to them. And I think it's something to just think about.
That's a fair point, Peter. Who's,
Michael Kopko has his,
Yeah.
and then Stephen Cohen.
and then what, sorry?
Stephen Cohen again.
Okay, so Michael, you first, and then Stephen, Mike, after Michael, please.
Thank you, Madam Chair. I just wanted to respond to some of the things that John Giorgio was talking about, and Stephen can chime in after me. But I think that my sense is that what we're looking to do is find a way to get to supporting the select board article in a in a way that we've just tweaked it a little bit here and there, so that there is one article that the FinCom and the board and everyone else has come to an agreement about. And it seems to me that'd be the simplest way to go forward.
Mm-hmm.
Stephen? Thank you, Michael.
So I agree with that. I don't count myself among the 3 people that understood what was happening last year. It's a bit of a joke, but maybe with John on that, it was a lot. The 2 issues with the select board article that aren't in mine, one of the reasons why they may not be is that those issues, affordable housing and timeshares, are already regulated in specific ways within the bylaw and through deed restrictions and those kind of things. And it may not be necessary to address them, especially in the affordable housing arena. There are already strict rules on whether they can be rented, how long you have to live there, like how often you have to be there. And it might be that those should just be left to be regulated the way they already are. And to the extent timeshares are their own sort of little beast, they could be regulated that way. It might be more complicated. I think that the timeshares might need a better look. So, for example, I don't know if they are registered in the way others are, because people only own 1 week or 2 weeks or 3 weeks. And they might be doing it under the exemption that you don't have to do it if it's less than 2 weeks or whatever that rule is. The house is not owned by someone who could register it in the way that other houses, a single family home is owned by one person or one, owner. So I think that those two issues might deserve their own special, or specific look, and may be better in a round two for this.
Thank you, Stephen. Maria, is there anyone from the select board on this call, on this meeting?
Don Hogate.
Dawn, I'm glad she's here, but she's not the one we can use. So no Brooke Moore, Tom Dixon, or Malcolm, because those were the three that voted in favor. Jill?
If the select board changes their article, if they tweak it, does it have to come back to them to revote it?
We can't. It's done.
Yeah, okay. I didn't know if they would
The only thing.
want to revote it or something for their own, maybe.
The only thing that,
Poster.
they can discuss it again, of course, and then ask the FinCom to make a motion to make changes per their discussion. That's right, John?
Sure. Yes.
So that would be the way forward for the select board to be able to modify what's in their article. And then to request to the finance committee, when we make our motion, that we adapt their changes in our motion, if we believe that they should be adapted.
That's getting tricky.
That's essentially what happened last year when Matt got up to speak, and that's what made the confusion.
And also too, our motion too was very long, and it confused people as to what are we voting on? And honestly, I don't think people understood that they weren't voting on the article anymore. They were only voting on our motion. So I don't really want our motion again to be a source of confusion for the voters. Rob and then Jill.
I think I didn't see this in the comparison, but there's also
Closer to the mic.
sorry, I didn't see this in the comparison that came around, but there's a discrepancy in the grandfathering between the Cohen and Select Board versions as well, which was part of the confusion last year, I think, where the Select Board changed what the work group had put forth.
Right.
We changed it back, so
In terms of how to grandfather, yes. Yes, who was eligible for grandfathering compared to, yes, the select boards was much more narrow than what the work
having
group had put in
previously
place.
rented versus being a current owner, right? Which I think is a
It
big,
was
big
around
difference.
certificate of
Right.
occupancy, so to allow anyone, yeah. And there's Brooke, just in time. Just in time. You should be on a horse charging in, Brooke.
Can I ask a question?
Yes.
Mr. Cohen or Mr. Kopko, when would your regulations go into effect?
So Michael or Stephen, either one can jump in, please.
I can, it's the same answer for all three, I believe. A general bylaw goes into effect after it's been approved by the Attorney General, and the town clerk publishes it in the bylaw book of the town.
And would the owners have to do anything other than just be registered? In other words, before we were talking, the select board was talking about a certificate of occupancy by certain date and things like that.
Well,
Are we eliminating all that?
Steve, do you want to explain your grandfathering provision? Because the way the select board grandfathering provision reads, if you have a certificate of registration on the effective date of the bylaw, then you can continue to operate in accordance with your certificate of registration, regardless of what the bylaw says. So, for example, if a corporation has a certificate of registration, a valid certificate of registration on the effective date of the bylaw, then they can continue to operate. They wouldn't be subject to the no corporate ownership limitation.
Okay, I'm just, I'm looking at it just in terms of policing the situation. When would, if I built a house, no one was living in it, but I've already registered it, it's not completed, I don't have a certificate of occupancy. Am I allowed to participate in the program, my grandfather?
No. Don't you need your certificate of occupancy before you can register
That's
it?
what I'm asking.
Depends on which
Yeah.
article you're talking about, they're different.
No, I'm just talking in general. The existing bylaw. So did you read the existing bylaw? I think, I've read all four.
Yeah.
Several times. I can't remember off the top
I
of my
don't recall
head.
either.
In chapter 1, 2, 3, whether you need, I've never tried to register an STR. Therefore, I don't know if you need a certificate of occupancy to
either.
register it. Anybody know the answer to that? Looking around?
You don't need that to register with the state.
Okay, all right.
You don't need that.
So
But-
then, yes, Peter, you can register it. without the-
Okay.
There you go.
Okay.
But
that's
I
fine.
think
Well,
CO really wasn't the issue from the fall meeting. I think that was related to historic buildings downtown that don't have COs. I think that's why that came
No,
up.
that was actually written into the,
Eventually, but it wasn't there when we got there.
might have been, yeah, right.
Okay.
So,
Twice anyway.
so you have to,
Michael? Oh, go ahead. Who's speaking?
I'm sorry, Denise.
Okay,
So
go ahead, John. And then Michael.
I believe you do need to have a certificate of occupancy before you can register an SDR, because if you don't have a certificate of occupancy,
No one can
no
see.
one can occupy that unit.
That might be true locally, but not with the state.
Yeah, right. Well, right. And so, and the Board of Health has authority under the existing Chapter 123 to enact regulations. So if we have to clarify things like that, the Board of Health can do that in their regulations, which, by the way, have to be approved by the Select Board under 123.
So I would agree with John. I actually think that the inclusion of the CO in my article is not the best place for it, and that should be a registration requirement, not a STR requirement. So I would have no problem with that being eliminated and just relocated into the Board of Health regs, which will also have a dozen other prerequisites to get your registration certificate. Pay your taxes, have proper sanitary facilities, those kind of things.
Thank you, Stephen. Okay, Brooke, to catch you up. Basically, has come out, let's see if I can do this simply. There is a preference to have the Select Board's article be the last one standing. And then Mr. Kopko's and Mr. Cohen's articles would be take no action or whatever it is. John has pointed out that all three can go to the voters and they can vote all three, provided that there's modifications, and then all the three end up with what is the new 1 + 1 + 1 = 1, basically at the end.
No, I didn't quite mean, if that's what I said, Denise, I apologize. That's not quite what I meant. What I meant was that the motion on town meeting floor, and let's assume it's the modified version of the Select Board motion. If it has elements that were not in the Select Board's warrant article, but were either in Kopko or Mr. Cohen's article, then it would be within the scope. Okay.
All right.
But of course, if, for example, there's been some discussion about deleting the interval ownership prohibition, if the final motion just deletes that altogether, then there isn't a scope issue because it's deleted, it's not added, if that makes sense.
Okay. So, and Mr. Cohen and Mr. Kopko have both said that they would be in favor of one, preferably one supported by the Select Board or sponsored by the Select Board, to go forward. The dilemma we have here is, how does that work get done to get to what is potentially, what are some things that may need to change in the select board article? And then the select board could do the work and ask finance committee to make a motion, including what the new changes are. That's the only way it could go forward, because you can't do a new article. And please leap up to the microphone, Brooke. That would be great.
Hi, Brooke Moore, Select Board. So here's what I'm thinking. What is your timeline for having to complete this?
5 o'clock. On March 13th.
Okay.
So
Here's what I think. I think that I should raise this at the Select Board.
okay.
The concept of appointing a select board or identifying one select board member to meet with Mr. Cohen and Mr. Kopko, and perhaps some note taker or someone who could, or maybe someone even from FinCom, who could then listen to that conversation so that it's properly communicated to the Finance Committee when you go about making your motion, and consider, I guess, work with them to try to figure out how to get to a version that is amenable to everybody, that then in an ideal circumstance, they would then communicate that they would prefer that their articles not be voted on, and that the agreed upon one is the version. Now, I'm one select board member. I cannot speak for the entire board, nor can I anticipate what would be acceptable as a compromise that added things to the select board version. For instance, I could imagine perhaps taking something out, like the interval fractional piece. I think where it's going to get a little more dicey or more complex is if there's stuff added, because I think the five of us have very different views about the different components of this, honestly. So, I mean, we're just a small version of what went down at, the special town meeting, right? It's the same concerns, worries, fears, desires, reflected in the community. So
I think the tone of the conversation tonight so far has been basically taking stuff away versus adding. So Mr. Cohen's and Mr. Kopko's versions may have something they want to add, but I haven't really heard anything that they've said, please add. The significant difference between between the three articles is that the select board version has a lot more in findings, and maybe some of that is not necessary, but it doesn't affect anything, so I guess it could stay in. And then the interval ownership and the timeshare. So, and the select board does do grandfathering.
Yeah.
Very differently, though.
If I may, Madam Chair,
Sure, John, go ahead.
I wouldn't gloss over the findings exactly, because I think Mr. Cohen's point that he made was some of those findings may be too controversial and create some issues at town meeting. So I would guess that when we got to an actual final product, some of those findings might be deleted. The only thing that I can think of that would be potentially added to the select board's version is the prohibition on tents, which is included only in Mr. Kopko's version. There's been some objection by Mr. Cohen to the no affordable housing piece of the select board's articles. So that
Actually, John, I'm going to stop you there to correct you. Stephen said he would be fine with the no affordable. It was Peter Schaefer who raised that as an issue.
Well, I'll let Steve respond to that, because I thought I heard an objection there.
Peter raised it, and I actually think he made a good point. And what I said was that issue may be one that we want to deal with separately, and it may be unnecessary because there are so many restrictions on affordable housing anyway. So it may just not be one we need to deal with in this article because it's already regulated. And it could be regulated separately.
may I, Madam Chair?
Please,
Okay.
Brooke, go ahead.
So I'll speak for myself alone, right? We went through a long process of trying to come up with what turned out to be a pretty complex set of proposals in the fall that tried to address this much. When we discussed it at the select board level, whether to include an article, my goal was to focus on the things that seem to be broadly acceptable as a starting point that may not be enough for some people, but are acceptable to enough people to get going, and maybe have the community realize it's not the end of the world if we start somewhere. And I mean that I mean that seriously. I mean, there's a lot of concern, a lot of worry, a lot of fear. There's people's financial livelihoods behind what happens with these regulations, and I think that I want to acknowledge that and say, okay, what was the general consensus? And I think it was the corporate ownership piece. And my understanding from the short-term rental work group is that there were concerns about the legality of removing the right that had been available to a corporate owner. And so that starting with, we stop it here and it doesn't grow as just step one. And then we see how it goes. We see how the platform goes. We collect data, we learn more. We learn about the impact on affordable housing, deed restricted ownership, and the financial impact, and whether we want to allow some room there over time. I mean, I think this is an opportunity to start somewhere. Maybe lowest common denominator is the phrase that I would use. That is acceptable.
Thank you, Brooke. So don't go anywhere, Brooke. Stay there. No, I mean, stay at the microphone. Jill?
If I could just, the lowest common denominator, though, I think what we're discovering is Steve Cohen's article, right? Because he really just goes after the corporate ownership. So if you felt like you needed to reduce, I do feel like his is a little simpler for people and straightforward.
Yeah. So I don't have all this language in my head coming to you today of the different versions. So that's why I really think a sit down with all three article sponsors, Select Board, Mr. Cohen and Mr. Kopko, is the way to go. And I think quickly, I can't make that decision unilaterally, obviously. So it would have to come on maybe as new business this week, to be ratified the following week. And I defer to the town manager on process on that. So, yeah, just what would be the appropriate way to open the conversation about appointing someone or assigning someone the task from the select board? I'll repeat what you said.
I'm afraid I cannot hear that.
Yeah, so I'm going to repeat it. What the town manager suggested is that I bring it up in select board comments this week and ask that it be added to an agenda at a future meeting as quickly as possible. So then after that, and there's consensus from the select board, official consensus, then we could convene the three groups to come back with a proposal, a compromise.
Our last date for making motions or making recommendations is March 12th.
Yeah. So
getting in this March 11th would not be helpful.
Which is why
I'm just pointing out that we really need it as soon as it can be.
Yep.
I'm going to look for volunteers to be the fourth member of that merry band that's going to sit down. Does anybody in particular? If not, I will do it. But I think one of the FinCom should be at that meeting to help kind of take good notes. I need to do it.
Yeah, because this is going to be processed with the motions. I mean, this is going to confuse people again. And if you really want something, what I kind of am wondering, sorry, I didn't ask to speak, but
No, yeah, I was looking at you.
I'm just thinking process. If you don't get the result you want on your article, or the select board article, right, you might want to turn around and endorse Steve's article to get something, right? So I think because of that, you should do it, Denise.
Thank you for volunteering me, Jill.
So I agree. I think we need to move it along as quickly as possible to leave room for diversions from the ideal path that I sort of laid out. Yeah, I mean, and I think having town council there would probably be really helpful too. So
Okay, I'll do it with
yeah,
you.
I'll bring
So,
it up Wednesday night and we'll get the process going.
Thank you, Brooke.
Right.
Okay, so anything, what,
Madam Chair,
Yes.
Michael Kopko has his hand raised.
Michael?
Yes, thank you, Madam Chair. I just want to say, I think we're really, really close. In my discussions with Stephen, my sense is that we can come to a consensus really quickly on this. And if anything, I think we're all trying to get at I think Brooke said it well. We're all trying to get at the main issue of corporate ownership. And I think simplification of language is also key. So, and my sense is that Stephen and I imagine the select board are all in agreement about all of these things. So,
Thank you, Michael. Okay, so our next step is we've now passed the baton to Brooke for at least a few minutes till it comes back our way. Thank you for that, Brooke, very much appreciated. And we will continue through our public hearing and Stephen and Chris, what?
I'm sorry, Stephen Cohen has his hand raised.
Okay, Stephen?
Just super briefly, I just wanted to agree with what Michael said, but also just, sort of for public consumption and perception issues, I don't think that what we're going for here is the lowest common denominator. I think what we're going for here is the strong base of consensus. And I hope that's what we end up with. And I think that's what people should be thinking that we're going to end up with at town meeting. I just like to keep things positive. Thank you.
Well said. Thank you, Stephen. Okay, so Stephen, Michael, thank you for being here. And the conversation continues. So I'll see the three of you soon. So good. All right. All right, back to the public hearing. Stephen and Chris, please come back. All is forgiven. So there we go. As they rejoin us, the next one up is actually Article 63, bylaw amendment, street and sidewalks. We made a motion to adopt unanimously on February 1st. The next one up is bylaw amendment, car rental agencies registration of. We will be discussing this one tonight, and I want to know if the committee has, after reading the additional paragraph that was inserted in the car rental registration of bylaw, if they have any questions on that paragraph that they would like clarification on.
Where is that paragraph?
It's at home. Article 64, it's paragraph E. My question is, and Libby, I don't know if, or maybe Amy, bless you for being there. It doesn't say, so it says in the article, if the town obtains information suggesting that a rental agency is holding one or more RMVs that are not in use, the select board may conduct a hearing, blah, blah, blah. Is there a time, is it time bound of how long it's not in use? Do you know? Because it's just, if they just know it's not in use. Okay, so they're not limiting themselves to it has to be not in use for 2 years, or it's not in use for 3 minutes, or?
I can't hear.
Okay, so Libby, I'll repeat what she says. I'm her translator. She says it'll be at the discretion of the board. Is there more?
And it would probably be something.
Yay.
Oh, look at that.
Amy
We've
Baxter
come a long
has-
way.
it's- Amy Baxter is.
Okay.
Thank you. Where was I?
It was at the discretion of the board.
Yeah, discretion of the board, and it would probably be something, you know, considered reasonable, like not a week, but something more significant.
Probably be over a year or over several months, because
Perhaps
if they've
several
registered
months.
at the beginning of the year, then it's,
Yeah, I think we'd probably need to undertake a kind of a review of where we are right now with outstanding RMV medallions and kind of determine how long some of them have not been in use.
thank you, Libby. Amy?
She's muted.
You're muted, Amy.
Can you hear me now?
Yes, we can. Thank you.
Thank you so much, Madam Chair. My understanding, I don't have it right in front of me right now, was that there was language regarding a deadline of filing their renewal forms each year by October the 1st, I believe. That was something we wanted, so that at that point in time, any unused medallion, and that means that a medallion that was not attached to a registration, would go back into, I'll just say, the pile that the select board again would review and determine whether they would retire that medallion or seek a process to reissue that medallion. And also, as Libby mentioned, we do have a process right now to kind of go through what we have to see what medallions may be available in the process right now.
Thank you, Amy. Okay, any other questions from the committee? This seems pretty straightforward to me.
I've got
Sure.
a question. Joe, what are the requirements to get a medallion? Can anybody apply to get a medallion?
You have to be registered as a car rental agency, and then you apply.
Okay, and how do you get registered as a car rental agency? Is that
The
a
way
town?
the way you register a business.
Is that a town requirement, or is that
It's
a
a
state,
it's a-
federal?
well, how do you register a business?
It's, I'm sorry, it's already in the bylaw,
Yeah.
how you do it.
I'm sorry,
It's already in the bylaw, how you do it.
it is in the bylaw?
Yep.
But also, it's I'm starting a business and I decide to register it and
Well,
blah, 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 and
it's laid out all in the bylaw, how you obtain the license, how you obtain the.
I'm sure
the
Amy can help
medallions.
out again. She has her hand.
okay, Amy has her hand up.
Okay.
Thank you, Amy.
Yes, Madam Chair. Libby was describing it as I would have answered as well too. Is it in the bylaw? Excuse me. There has to be obviously available medallions at that point, which we don't have at the time, so that would not be able to be issued. So it was based on, I believe, when the bylaw was enacted, as far as what the agencies are, and this seeks to also create a better definition of a car rental agency.
Madam Chair,
Yes,
Joe Wright has his hand raised.
Joe, please.
It's Joe Wright. Madam Chair, my reading is that the increase in the number of medallions from 700, that is gone.
That's Article 65, Joe. We're on Article 64.
Okay.
So there's an Article 64 that was put in by the Select Board to amend the bylaw of their own, and then there's the citizen who put in Article 65, which comes up next.
Okay. Thank
Thank you. Thank you.
Madam Chair, John Purton has his hand raised.
John, Mr. Purton?
He's muted.
You're muted, Mr. Purton.
All right, is that better? Can you hear me now?
We can.
Thank you, Madam Chair. Madam Chair, my name is John Purton. I'm the attorney for Nantucket Rent-A-Car as well as Affordable Rentals. With respect to Article 64, my clients have no objection at all to the definition amendment at 58.1. We do have a concern with Section E, 58.3, Section E as in Edith, in that Section B as in boy of the current bylaw says that the medallions are a non-expiring right to lease one motor vehicle. And Section D as in dog provides that holders of medallions can transfer them for consideration. So that makes them, we believe, some sort of a property right. And we believe that that E is inconsistent with B and D, and it also raises potential constitutional issues on takings. So for those reasons, we would like to bring that to the attention of the committee and oppose that new section E. Thank you, Madam Chair.
Thank you, John, or Mr. Purton. John Giorgio, you are best placed to respond to Mr. Purton.
Thank you, Madam Chair. So I would respectfully disagree in terms of the property right. The select board cannot act to essentially retire a medallion without first conducting a public hearing. And so that would satisfy the deprivation argument, I think, if it is in fact a property right. And I think you have to read all of these sections together as a harmonious whole. And I think it's quite clear what the rights are with respect to medallion holders. And subparagraph E would only be invoked by the select board if there was some cause to believe that a medallion is not being exercised. But they would have to hold a public hearing first.
Thank you, John. Questions from the committee? Rob?
I think a question for Mr. Purton. So the way that this language is, it basically says you have to have a copy of your registration for the vehicle when you file a renewal application. And we heard in the last time we talked about this, that these vehicles turn over constantly, right? They're changed out over the winter. I just don't know if that practically poses a problem, or is it just the inconsistency with the other sections that he's objecting to?
Mr. Purton, do you want to answer
Sure.
Rob's question?
Yes, thank you, Madam Chair. The concern really, it's more than anything, it's a grandfathering question. That is, we read B and D. Each holder has these non-expiring rights, and by adding E, you're making them expirable by the board. They can be taken away. And to the extent that we believe these are business assets, if you will, of the entity, which in theory anyways may have been pledged to secure loans or whatever it be, to the extent that you can be divested of this right, there's a concern. So I hope that helps clarify. Thank you.
So I've been issued an RMV. I rent a car for 2 or 3 years. I'm a car rental. It's, Denise's Rentals. I rent a car for 2 years, and then I decide to, you know what, I'm going to go to the Bahamas for 5 years and not rent cars. So, but because it's non-expiring, it sits in my drawer. And the community is down one rental car because I'm not exercising so you're saying I deserve to keep this RMV in perpetuity, even if I may not be actively engaging in the business by, I don't want to say fixing on, but by sticking to the language of non-expiring. That's for you, Mr. Purton, by the way.
Thank you. I think taken to its extreme, Madam Chair, that is correct, although as a practical matter, if there is a demand for the rental medallion, it will be utilized, right? I mean, it makes no economic sense to have a medallion and a car that you could rent and not use it. So I guess yes, in an extreme case, what you pose is theoretically possible, but as a practical matter, I don't believe it is.
Amy, I'm going to ask you to give me an estimate of how many medallions are probably in the drawer at my desk at home.
Yes, Madam Chair. So how it works every year is we do the renewal licenses, excuse me, at the end of the year. And that is for the agency license. And then as the cars either come over or they are bringing registrations, they bring their registrations in for the medallion and beach stickers if they need them, that sort every year. So every year, I'm going to say, and I would say 99% of our agencies use most, if not all, of their medallions. And we get that by summer. There is one that does not. And over the past 6 or 7 years that I've been doing this, particularly, I would say the average is 100 medallions are not used and are just paid for. As we've talked about, if the car itself that is brought to us, the registration is Nantucket, there is no fee for that medallion. If it is a off-island registration, there's a $100 fee for each medallion for off-island registered cars. So we have an average of, I'll say 100, sometimes more than that are not being used, but are being paid for at $100 per medallion to basically sit on.
Okay, thank you, Amy. Stephen? Thank you. Is yours on?
Thank you. Through you, maybe to John or to Mr. Purton, what does the last sentence of section D as in dog mean? The last sentence.
So it's any RMVs not attained by any rental agency by the end of any calendar year shall be considered surplus as of January 1st and may be retired by the town at that time.
So if there are fewer than 700 medallions issued, so let's say there are 10 medallions that are not applied for renewal, those 10 would be retired. I don't know how Amy interprets that, but I think that's what is intended.
So then the 100 medallions that on average are not used, are those considered to be surplus under this language or not?
I think Amy should maybe answer that question, how the department has interpreted that.
Please, Amy. Thank you, John.
Thank you, Madam Chair. Yeah, I agree with that wholeheartedly. I think this has been a longstanding practice that we've inherited. I don't know where this started or was a policy that the agency would pay for this medallion. But we agree that this in this language was meant to possibly make it a bit earlier in the year to determine who has registrations by a certain time. But it's been a longstanding practice that we're looking to, change and make sure we go back to what the intention is. So yes, they would be surplus.
Other questions? Rob?
So why do we need E if D already provides for this?
My understanding is that, okay, I'm still use Denise's rental car company. I have 100 medallions. I'm only actively using 90, but I pay for 100 in the case I want to add 10 more cars. But I'm actually not going to add 10 more cars. But I've got the medallion because I earned it before when I had 100 cars. And Amy, if I'm wrong, please correct me. I'm always happy to be corrected. Libby's going to correct me this time.
Well, I don't think I'm correcting, but what I'm saying is that this is more of a situation where if no rental agency has these medallions assigned to them, they would become surplus. So any RVMs not obtained. So the problem is they're obtained, they're not used.
Yeah, understood.
Denise?
Yeah, first Jill and then John. Was it John?
Jeremy.
Jeremy, okay, sorry. First Jill, then Jeremy.
Is the difference, and forgive me for getting into is the difference that in B, you've just asked for a list of cars, and then in E, you're actually asking for their registration of that car? Am I reading that right? Because that is a different way to apply for a medallion.
Amy, I think that would have to go to you.
Okay, so you're asking then if the difference is first a rental agency license versus a list of cars, it would be, the list of cars would be the registration. So if there's a discrepancy there, I think that's what it means. But it is a registration. The only way to get a medallion is with a current registration.
Gotcha. Okay, that's what I wanted to make sure.
Thank you, Jill. Jeremy?
Yeah, it just strikes me that 100 that are generally out of use out of 700, 15% that are not used, that's quite a large number when you are essentially giving an oligopoly to people. And so it strikes me that the select board should have the opportunity to take that back and reissue it to someone who will use it. The net effect of course, are the existing participants won't like that. But that from a public policy perspective, the whole system-wide should then enjoy greater efficiency and lower cost to consumers.
Thank you, Jeremy. Joe, right?
Is Joe right? Am I correct? And I think this is a question for Amy. Am I correct in understanding that the only barrier to someone looking for the lowest excise tax environment is the $100 fee? And that's the only thing that someone pays if they don't pay excise tax in Nantucket. Is that correct?
Yes, that is correct. They pay a license fee of $100, and then, like you said, Nantucket, $0 for the medallion if it's registered there, and $100. Yes, that is the fee.
Are we going to encourage excise tax shopping?
I can't answer that on how we're going to do that, but we're certainly just trying to at least clean this up, bring it a little more into modern days, and then take the next step from there.
The fact that my understanding is that none of the people that were renting cars without medallions have those cars registered in Nantucket. Is that correct?
I would
off island.
Well, after our last meeting, we certainly found that some were obviously registered off island. I don't think that's a majority. We had a large group that were very clearly running commercial type operations and not just renting their own personal vehicle. We have a great number of people out there renting their personal vehicles, and they live on Nantucket. So I couldn't really say what the percentage is there, but it goes both ways.
I just think $100 is a deterrent for someone to go find the cheapest place with excise tax, and that may result in Nantucket actually losing money or income.
Anthony Panebianco?
Oh, yes. Mr. Panebianco?
Yes, thank you so much, Madam Chair. Attorney Anthony Panebianco here, just to be brief. I represent the Hertz Corporation and wanted to state that we agree with the assessment that Attorney Purton has made regarding the article before us. Although predominantly we're here to talk about the following article, the Citizen Warrant article, I did want to acknowledge on behalf of the Hertz Corporation that we agree that as written and as applied, we do not believe that this present article should be approved. We do think that there is a conflict written within it as well, and that the current way that it would be phrased and looked upon, we believe would amount to a take, as Attorney Purton said. And the grandfathered in of whether it's the Hertz Corporation or other current owners of the medallions to have, while it's a process, it would essentially be a process of taking based on new standards would be inappropriate. Forgetting or putting aside that there are conflicts within the language of the article as written, we do think that if approved, it would be a tantamount to a taking, which wouldn't be appropriate in this session. So We respect and understand the committee's issue on this of the outstanding medallions and how they're utilized and the best use for the island and how to do that. But as written, we don't think it's appropriate.
Thank you. Okay, Libby?
I was just going to add that we heard from town council weigh in on this already, and if it is truly illegal, then the Attorney General won't approve it.
Okay, thank you, Libby. Chris?
I don't know if it's a taking or not, but I do know that there's a ton of inconsistent language in here, and this whole thing needs to get rewritten. It's so confusing to the point, Stephen's question. I think when you do have things like non-expiring right and transferable with consideration, and then you go to your issues about how the timing is just going to be reasonable, it's not fixed on anything. This seems like it needs a complete rewrite to me. I guess the question in front of town meeting is just, is it enough of a tweak of an improvement as a first step, or do we just need to back to the drawing board, would be my question.
So to piggyback on what Chris said, is this a motion to refer for further study, to rewrite the whole thing, or is it the adding of E a helpful first step to address a significant problem on the island or in respect of this topic? And then it does not preclude going back and fixing the whole thing as well. I mean, I know when I met with Amy, I hijacked her in the hall here and she helpfully spent 15 minutes with me. And she did say that, these are from the 90s and it's probably time to take a look at this in general. So, like a lot of our bylaws, that anything that's probably 30 years old probably needs some attention. So, but I also look at, whoever's not muted, can you please mute? So I also look at E as maybe just a helpful start for the town to be able to start that and then go back and clean up the other things. If that's Maria? Joanna?
Hi. I agree with Chris. I think that this is extremely confusing, and although it's a good idea, and I agree with you with everything you just said, that it needs to be cleaned up, I think it needs more work, and I would support referring it to the appropriate group of people who could help make this make sense, because I think that, as we've seen in many other cases, this is going to be a situation at town meeting where people don't understand what we're asking. Rather have it be right.
Jill?
It seems like what this is trying to do, I'm not saying it's doing it, but it's trying to give the select board more latitude, right? And I do want to support that. So I personally am in favor of this. How Amy and the licensing board interprets that, it's really up to them. And, I would hate for them to be sued or something like that, but we can't stop those.
Thank you, Jill. Joe?
Oh, I'm sorry. I have a question for Anthony. Are any of you represent two of the cars that we're renting on Nantucket? Are any of their vehicles paid? Do any of their vehicles pay Nantucket excise tax?
Actually, Joe, it's for John. It's for Mr. Purton. Anthony represents Hertz.
Okay.
So, and I am not sure that the excise, whilst I understand your interest in this, and it is a valid question, it is really not part of this article nor the next one. So I think we have to take that offline and maybe add that to something we would think about separately. But I really don't want to get into who's paying excise tax and who isn't. It's just not part of this article. It is an opportunity potentially for the town to make some more money. I always like that. But it is not part of this article. So, Mr. Purton, I'm going to ask you to not answer that question. Sorry, Joe. Thank you. Jeremy? You're muted, Jeremy.
I read this as giving the select board the ability to be efficient in reissuing these unused certificates. And so I think this makes sense and I would certainly support it.
Thank you, Jeremy. Is there any further discussion, or can we go to a potential motion? There's further discussion, Chris? Oh, okay, you were nodding yes. Okay. All right, then. We are out of practice being in this room, or I am at least. Okay, do we have a motion, a proposed motion?
Motion to adopt.
Motion to adopt. Second.
Okay, so Jill made the motion, Jeremy seconded. All right, and now I'm going to close the public comment section, so now only the Finance Committee can deliberate. May I have any further discussion on the motion?
Denise, if I may,
Go ahead, John.
this is a public hearing, correct?
Oh, yeah, that's true. Yeah.
Oh, you should ask for if there's anybody else that wishes to speak. And if not, you should take a motion to close the public hearing on Article 64 only.
Thank you, John. Okay. Is there anyone else that wishes to speak, Maria, on Article 64? Okay, seeing none, may I have a motion to close the public hearing?
So moved.
It's made by Chris.
Second.
By Stephen, thank you. Roll call, so Joanna?
Aye.
Joe? Joe, are you muted?
You waved.
Oh, you waved, okay. My back is to you, sorry, Joe. Jeremy?
Aye.
Chris?
Aye.
Stephen?
Aye.
Peter?
Aye.
Jill?
Aye.
Rob?
Aye.
Denise, aye. That's unanimous. Okay, we've closed the public hearing on Article 64. All right, so the motion in front of us is motion to adopt. Is there further discussion on the motion? See anybody on the screen, Maria? Nope, okay. All right, so by roll call, Joanna.
Why do I cannot go last?
Joanna, you can go last.
Thank you.
Okay, Joe.
Next to last, please.
Folks, actually, I have got one nerve left and everybody's jumping on it right now. So let's have some discipline here, okay? Rob?
Nay.
Okay, Jill?
Aye.
Peter?
Nay.
Stephen?
Aye.
Chris?
Aye.
Okay, Jeremy?
Aye.
Joe?
Nay,
Did you say nay, Joe?
I did.
Okay, thank you. Joanna?
Nay.
Okay, and Denise is aye, passes 5-4. Motion to adopt. Okay. All right, Article 65. I definitely doing that one. Or nay. I think in my whole time on FinCom, that's the first time we've been 5-4 on anything.
I think so too.
In my whole
think you're
time.
right.
Yep.
Yep.
Okay.
I don't know, the flushable wipes, it was tight, right? Seriously, I think it was tight.
Okay, Article 65. Is Rebecca here?
In the nipple.
Okay, yeah. Okay, Rebecca, please share with us your, give us an overview of your article quickly, and then why you're looking for a positive motion from the Finance Committee.
Thank you, Madam Chair. My husband James and I wrote this article together. As sponsors of Article 65, the goal of our article is to create what we believe is a fair rental car medallion system that is inclusive of island residents. The current system has not allowed one new legal entrant to enter the rental vehicle market in over 25 years. Nowhere else in the United States of America are rental cars regulated in this fashion. In opposing such a system, the town has the obligation to ensure it is equitable. As I'm sure you understand via the town's efforts to retain employees, teachers and firemen, police officers, and many islanders need additional sources of income to afford to stay on island. Article 65 gives the Finance Committee the chance to support local families by providing equal access to these medallions, some of which, as you mentioned earlier, have been held and not even used by the largest medallion holder, Hertz. While the town's newly concocted Article 64 seeks to tighten the Chapter 58 bylaw, the Finance Committee now has the opportunity to do the right thing here for island residents by supporting our article. Thank you.
Thank you. Thank you, Rebecca. I'm going to look to the members of the committee to ask questions. Peter Schaefer?
Yeah, Rebecca, how many, to the best of your knowledge, how many individuals use their vehicles as a taxi today?
The car rental.
Car rental, I'm sorry, car rentals today.
I'm sorry, I'm not clear on the, I'm not clear on the question.
Yeah, you're saying that there's so many people that need to get medallions so they can operate a car rental business. How many people are we talking about? The best of your knowledge?
I believe the complaint that was filed in July cited about 200 individuals on Turo, and I think there were 4 small businesses that have been coined illegal that were shut down. My husband and I have only 2 cars.
One of those quote unquote illegal businesses.
Okay, I guess we really don't know the answer to the question then. Thank you.
She said about
that was addressed in the complaint that was sent to the town. And we said that there was 150 to 200 people on Turo and 4 other companies in the complaint.
I would estimate the total at 250 cars. If you want an exact estimate, I'd say 250.
Thank you. Thank you, Rebecca. Rob?
So just in light of the prior discussion and the positive motion on 64, does the need for this now go away since Turo renters will have an opportunity to apply for a medallion?
We're not renting through Turo because we have commercially insured vehicles.
Wait, hold on. Wait, please. One person talking at a time. I have to recognize you. Rob was speaking, and then I'll come back to you. I'm sorry, sir, I don't know your name. I just know Rebecca.
This is like Rebecca said, this is her husband, James Broad, who's a co-owner in Becky's Broncos.
Thank you, James.
And a co-sponsor of this.
Yep, let me have Rob finish his question, and then I'll happily ask you to speak. Go ahead. Why don't you start from the top here, Rob?
Just in light of what we just discussed, where now the prior article permits Turo renters to go through the process of getting a medallion, right? That was the
or
first
any
part
rental
of the
car
prior
company,
article, or
any rental car business.
And we know that we'll be freeing up about 100 or so, right? If 64 goes through, this article is asking for 100 to be issued in 2024. Is it still relevant?
Okay, thank you. Mr. Broad, did you want to say something?
I'm gonna refrain from comment here.
Okay, all right. Chris?
I do have a question, but I know Jeremy and Joe have had their hands up ahead of me if you.
Okay, so Jeremy, you first, and then Joe, and then Chris. Thank you.
This is a legal question. Where in the end of this article, it proposes priority of distribution to Massachusetts or Nantucket residents as opposed to someone else. And from a legal basis, is that legal that we can prohibit someone from doing business of where they are registered in Nantucket?
John Giorgio, would you like to answer Jeremy, please?
Well, that's a very complicated question, Jeremy, and it does not lend itself to a yes or no answer. How's that for a legal response? If you recall, when we were dealing with the short-term rental regulations, that was quite an issue that was discussed among the work group as to whether or not placing a residency requirement as a condition of being able to engage in a short-term rental was constitutional. And the question is really whether or not it violates the Equal Protection Clause of the Constitution or it violates the Due Process Clause. And there is developing in the short-term rental context a body of law that would suggest placing a residency requirement as a condition of operating a short-term rental might run afoul of those constitutional provisions. Having said that, there is some case law in Massachusetts that recognizes the valid public interest, if you will, or public purpose in treating residents different than non-residents. I do think, though, that my recommendation on balance would be to stay away from those kinds of restrictions.
Yeah, it seems to me that those are, well, then you have the whole interstate commerce issue, which I suppose is also applicable here.
Yeah, but equal protection, due process, and yes, there is a issue under the dormant clause of the interstate commerce clause.
All right, so that it's a very gray area, murky, and the litigation involved in getting a real answer to that would dwarf the economic value of what's going on here.
It would be a significant
to you.
If I may, Madam
Okay.
Chair, and
Thank you, John.
You're welcome. Yes. So
you're welcome.
Do you remember earlier when I talked about how we have two articles, 64 and 65. The Finance Committee has moved to adopt 64. We've said in the past that 65 is a problem because it's not written in bylaw form. And if the board wants to adopt or recommend adoption of 65, we would have to figure out a way to turn it into a proper bylaw. The other thing, the finance
we can do that pretty easily. Thank you.
If I need to assign a letter to each paragraph, I can.
Point of order, Madam Chair.
That.
I think
I haven't finished
speaking.
I'm sorry. So one of the things that the Finance Committee could do here, and I'm not saying this is the way you should go, but if there were pieces of 65 that the Finance Committee thought was good public policy, you could recommend those provisions, and then we could put them into a motion under 64. Just as an example, 64 limits the number of leases available at 700. 65 talks about 300. If the Finance Committee wanted to increase it, by some amount, maybe not all the way up to 300, whatever, we could actually put that in 64, which is already in proper bylaw form, if that makes sense.
Okay, thank you, John. Joe, you had a question?
Yeah, I can live with 64, but as far as 65, I think this is something where we should see what happens in the year that is ahead, and not do 65 until we have some experience with what happens in 64. How many of the unused 100-ish actually get used? I'm also in favor of letting individuals, and this is sort of like short-term rentals, but letting individuals rent their cars, but not corporations. And so I'm in favor of a individual person who wants to rent his car from time to time being allowed to do that if they get a medallion, but not to have a corporation come in and rent 30 or 40 cars, and at the same time devalue the people that have been renting on Nantucket, devalue what they have forever. I don't see any evidence of lack of available rental cars in Nantucket, and I do see evidence of too many cars in Nantucket.
Thank you, Joe. Chris?
I'm ready to move on.
Okay. Further questions?
Madam Chair?
Yes?
Courtney Simmons has her hand
Okay.
raised.
Thank you. Please, Maria. Courtney?
Hi, good evening. My name is Courtney Simmons. I'm an attorney with the law firm Davis Mom. My co-counsel, Anthony, spoke previously. We represent the Hertz Corporation, And I just wanted to speak briefly on our opposition to this citizen warrant article 65. Some of the points that have come up tonight were already briefed in a letter provided to the committee on January 16th. I just wanted to comment on some of those points. First, as it's been discussed today, providing Nantucket residents and Massachusetts-based businesses and corporations with priority of distribution and redistribution of medallions over all other applicants that are seeking medallions does treat people situated similarly in a different way for really no rational reason related to health, safety, or general welfare of the public. And it's pretty clear, as laid out in the intended purpose of the bylaw, that the purpose is to generate income specifically for Nantucket residents and allow them to enter the market. And that's singling out a portion of the population based on location purely for providing those people with an economic benefit over other similarly situated groups or entities or individuals. I believe that it also has an unreasonable infringement on the right to pursue trade or commerce and enter in the business. I also don't, there's no basis for the statement made by the proponent of this article stating that Hertz hasn't used the majority of its medallions. I'm not sure where that information came from. Hertz does currently hold over 20% of the available medallions. And so the other main portion of this warrant article that Hertz opposes is that by imposing a 20% cap on the total available rental medallions, that is an improper taking of private property. And in this case, there is no public hearing process. There's no chance for anyone to be heard about whether those medallions are in use or not. And there's no process for just compensation. So unlike the procedure laid out in Article 64, which does seem to contemplate there's that due process component, we don't have that here. So for that reason, we feel like that is a legally invalid basis for this warrant article. Additionally, the terms resident of Nantucket and what exactly constitutes a Massachusetts-based business or corporation is so ambiguous and vague that one could foresee that the way that that actually is applied in real life presents a risk that it's applied in an arbitrary and capricious manner, and the way that it's determined who gets priority, could be, subject to an arbitrary determination of what those terms mean to one individual versus another. So for those reasons, I don't believe that this is a proper, valid bylaw. It's inconsistent with the Constitution and other laws of the Commonwealth. I don't think that there are...
Courtney, I'm going to ask you to wrap up.
Sure. There would be comprehensive amendments needed to make this compliant, and we believe that the AG's municipal law unit would also agree with this assessment. So on behalf of Hearst, we're requesting the Finance Committee vote to oppose this warrant article. Thank you.
Thank you, Courtney.
Rebecca?
Okay. Rebecca?
Hi, thank you, Madam Chair. This is in reply to Courtney and actually a question. Some of her numbers were in fact not correct. Hertz controls 310 medallions. That statistic was provided by the town of Nantucket, not by myself. That's actually, but basic math, 44% of the medallions, not 20%. Over 100 of those, as we confirmed earlier, are generally being held and not used. That's also confirmed in the town's statistics. I would like to ask Courtney why they're being held and not used.
Courtney, if you have that information, it would be helpful for Rebecca. If you don't, then you don't.
So just in response to the comment about the percentages, I never said they held 20. I said they held over 20%. And then the cap that's being proposed by Article 65 imposes a 20% cap. So just to clarify that statement, and no, I don't have any information about who holds those unused licenses or why they're not.
You hold them, Courtney. That's what we're telling you. Hertz is holding them. It's on the town website.
17%.
What are you doing with them?
Are being
okay. Mr. Broad, Again, you have to be recognized by the chair to speak, and right now it's Rebecca asking Courtney, and then if you want to, I happily will come back to you. Okay.
I have no further comment. I'll let the whatever's shown on the town website speak for themselves, but I disagree with the characterization.
Okay, thank you, Courtney.
The facts. Disagree with the facts, Courtney. Go ahead.
Mr. Broad?
Yeah, I'm trying to feed my family over here and contribute to my family in a meaningful way. And Courtney's company, multi-billion-dollar multinational company, is sitting on medallions that my family could be using to feed themselves on this island.
And there's no comment.
And she has no comment and disputes the numbers that Nantucket has posted on their website. So,
and I thought.
And why are we supporting Hertz in this? Why are we allowing them to do this?
We don't support any other chains. I don't understand why Hertz is getting this preferential treatment.
Okay. I'm at this point, please, is there anyone else that wants to speak to this article?
Denise, it's Jeremy.
Hi, Jeremy, go ahead.
It strikes me that one aspect of this might be of benefit, and I would take John's suggestion, and that is the possibility of taking part of this to increase the available medallions over time. That is something I think would serve public policy in Nantucket. And I think that that would be a way also you will completely avoid any takings issue. So I would be in favor of adding increasing a bit over time to this, but I think the rest of it, from what I can gather, has some failings and would need work.
Thank you, Jeremy. Now, just as a point of order or whatever, if there was to be an increase in the number of rental car medallions, that is a select board policy decision. So I would defer that. I do not think as part of our review of the warrant, that would be a decision I'd want the finance committee to weigh in. I would want our elected policy board to make that decision, and they could always make an amendment on the floor of town meeting if they were to consider that and think it's something they want to do in May. So I understand your thoughtfulness around this, and I would say it is a select board topic.
I understand and I agree. You're correct.
Thank you. Okay, any other?
John Purton.
Mr. Purton, and please be brief.
Can you hear me?
Yes, we can.
Thank you. Thank you, Madam Chairman. This is John Purton again, representing Nantucket Rent-A-Car and Affordable Rentals. As to the constitutionality, we would support what Hertz's counsel has stated, so I won't belabor that issue. Just two short additional comments. We don't see that there's any demonstrated need to increase the number, especially if the proponent is correct that there are 100 not being used. That certainly suggests that we're not even using the capacity that's there, so I don't see why we should increase that. The other issue I would just like to highlight for the committee is there's a very practical problem here, which is where does one store those vehicles? Because literally they're going on the streets. So your traffic and your parking will just be exacerbated by this situation. And the balance of my comments, frankly, I think the board indulged me at the last session, so I'll rest with that. Thank you.
Thank you, Mr. Purton. Okay. Maria, anyone else?
That's it.
Okay, then I'm looking for a motion to close the public comment.
Public hearing.
Public hearing. Thank you, John.
So moved.
Okay, all right, we have 12 people making the motion on a 9-person committee. So Jill made the motion, Peter seconded by roll call. Chris?
Aye.
Stephen?
Aye.
Peter?
Aye.
Jill? Rob?
Aye.
Joanna?
Aye.
Jeremy?
Aye.
Joe?
Aye.
Denise, I have closed the, Denise, I have closed the public hearing on Article 65. I am now looking to the committee to see if there is an appetite to make a motion. And if so, what is it?
I would move not to adopt.
Motion.
Second.
Okay, motion not to adopt by Chris and seconded by Jill. Okay, thank you. Now I'm looking for any further discussion on the motion. Okay, seeing none. Oh, Jill? Are you on? Are you?
I'm done.
I don't really want to be on. I do want to, I'm glad this issue came up, and I feel like the select board actually responded. And so I think this has actually been good, even if tonight wasn't, it can be testy. But I am glad that the issue came up and things were getting worked through, and everybody will be made aware of what's going on.
Thank you. Okay, anything else on the motion before I call for a vote? No, in which case I'll start with Rob. Motion not to adopt is a motion. Aye, thank you. Jill?
Aye.
Aye. Peter?
Aye.
Chris?
Aye.
Stephen?
Aye.
Joe?
Aye.
Joanna?
Aye.
Jeremy?
Aye.
Denise, aye. That's unanimous. Thank you very much. Okay. Now on to, give me a second. My papers are all flying around here. We're now on to Article 66. It's a sewer article, if anybody, no one wants to speak to that. Article 67, we made a motion, it's home rule petition, establishment of coastal resilience district. We made a unanimous motion to adopt on that one. 68 is a real estate article that we will be discussing on the 13th of February. 69 is the Coastal Resilience District, motion to adopt, unanimous on that one. 70 to 71 are sewers, so those will come after we get a ruling for, or a recommendation from the sewer board, also known as the select board. Article 72, the bylaw amendment, repeal chapter 141, stretch energy code. I have invited Mr. Phones for February 15th. Articles 74 to 78 were all citizen warrant articles, and all of them were motion not to adopt. 79 to 83 were home rule petitions sponsored by the select board with motion to adopt. And as I'm going through these, Maria, I'm hoping if anybody wants to speak to any of the ones I've said, you'll wave at me.
Yes.
Thank you, Maria. Doing an outstanding job. Article 84 is real estate, and we already did make a motion on that. Motion to adopt. 85 to 88 were real estate by the select board. Motion to adopt. 89 to 90 are real estate to follow. 91 is a home rule petition, an act amending the charter of the county of Nantucket. That was unanimous, motion to adopt. 92 was a citizens warrant article, and it was motion not to adopt. 93 to 110 are real estate and will come to us on the 12th, as I said, I think, no, 13th. And 111 to 112 are the usual appropriation last articles that we will do when we do all the finance articles together, or most of the finance articles together toward the end of our process in late February and early March. So that has been the entire warrant. Go us.
Well done.
So any, going back to the agenda of the meeting, any further comments or questions on the warrant before I move to the next agenda item? And I promise we'll still be out of here by 6 o'clock. In which case, I'm going on to item number 5, committee reports, starting with Peter, our island home and solid waste, please, Peter.
Our island home, we're going on a field trip on Wednesday to visit some state-of-the-art facilities on the Cape. And that's where we are at this point, and we haven't met on solid waste in a couple of weeks.
Okay, thank you. Thank you, Peter. Town Council Study Committee, Jill?
We meet on Wednesday, actually, and the town manager is going to be in attendance along with, I think, town council. So that will be a great insight.
And I still have it to get it on our agenda, so.
Need you
soon.
to do that if you guys can.
Okay, Maria, I'll look at
And you
the
might want to
schedule.
do that. You might want to do that. I mean, you might want to watch what town manager has to say as well before you, so.
Always fascinating. I agree. Thank you, Jill.
wanna know.
And Contract Review Committee, Joanna.
We've just completed our rubrics and we have a meeting tomorrow to review them.
Okay. All right. Date of next meeting is Thursday. We're back to I believe we're back to the trailer, room A, and at 4 o'clock and hybrid. Any other business? Seeing none on the screen, Joe? Okay. In which case, I'm looking for a motion to adjourn.
So moved.
Peter made it.
Second.
Jill seconded by roll call. Rob?
Aye.
Jill?
Aye.
Peter?
Aye.
Chris?
Aye.
Stephen?
Aye.
Joanna?
Aye.
Joe?
Aye.
Jeremy?
Aye.
Denise, aye. Thank you, everyone, and thank you, Town Council. Thank you, everybody. Amy, thanks a lot for being here. Libby, Brooke, very helpful, much appreciated, and we'll see you on Thursday. I don't remember. I think, well, I have on the schedule, and it can be the 15th.